So one question we get asked a lot on DUI cases is, should we take the breath test? And did we mess up by taking the roadside test when they pulled me over?
Yeah, that is a common question. I mean, and the thing that most people don't realize is there's actually two different breath tests. There's the test you get on the roadside, the portable breath test, and then the test that you may be given if you go to the station, which is called the Intoxilyzer.
And they can use the portable breath test. We always tell people this. The portable breath test, the purpose of that is to determine whether you're under the influence, and they use that as a reason to arrest you.
Right. When you're getting the portable breath test, most of the time they're still investigating whether or not you're under the influence or not. And so that just gives them probable cause to arrest you or to conduct further field sobriety testing.
But it can be used in court.
That's right.
But Intoxilyzer can be used in court as long as it's done right.
Mm-hmm. Officers have to be certified. The machine's got to be calibrated. There's a lot to it, but most of the time, if you blow in the Intoxilyzer and you're over the legal limit, that makes your case harder to defend.
One question we always ask everyone when we're doing a consultation for a DUI is we want to know what happened at the scene. And obviously, the potential clients that we're talking to, they're the ones that know the answers to those questions. So a lot of times we want to know, for example, did you do any field sobriety tests?
Yeah, that's right. I mean, there's a lot of different field sobriety tests that officers do. You've got the famous one everybody knows, the one leg stand. You have to stand with one leg kind of raised out. You've got the walk and turn. And I know you've had some experience litigating cases with the nystagmus tests.
Right. So, again, just like the portable breath test, a lot of the field sobriety tests are not to be used in court.
That's right.
But they can be used as probable cause to arrest you. We joke that field sobriety tests are very hard to do, even for people that are not intoxicated. And that's a big reason why you can't use them in court.
That's true. A lot of it goes into is how you're initially stopped by police officers. A lot of times it can be a traffic checkpoint. And if that's the case, there's all kind of constitutional concerns that go into that.
A lot of people don't even realize, too, that for us to be able to defend someone on a DUI case, I mean, we spend a lot of time learning the law on traffic laws and the exceptions to the traffic laws, because if a police officer does not have enough evidence to pull you over for that traffic offense, anything that happens after that, most of the time can be thrown out of court.
That's right. If an officer says that you failed to use a turn signal at a road where you didn't actually have to use a turn signal, we can suppress a lot of what has come after that initial stop. And so that's our first strategy we look at is, why did this person come in contact with law enforcement? Why were they pulled over? And was it a valid reason for pulling somebody over?
And then obviously we get into the portable breath test, the field sobriety test. Very, very seldom are we dealing with interviews.
That's right.
In cases of DUIs. But yeah, one of the things we're going to want to know on your potential client call with us or meeting with us is what happened at the scene. It's extremely important. Also, one of the things that we get in a lot of DUI cases, and we tell people this, is that we're going to get a body cam and a dash cam. And a lot of times the body cam and the dash cam will either corroborate what people are telling us, and it'll corroborate what's in the police report. But that's not always available.
That's right. And when we do get the body cam, we want our clients to come and review it with us. We want you to look at it and see if it's what you remember, see if there's stuff happening off of camera that we can't see but you remember happening. There's really a lot that goes into it, but we try to investigate every aspect of the case.
And we don't ever really talk about this, and no one asks us directly, but that's one of the reasons why I think we're different than other law firms when it comes to DUI cases. Because if you hire us for a DUI, you're not just hiring Cameron McCormick or Bay Lawrence. You're hiring our law firm. And to me, we got the best paralegal in this field. And it's very seldom that a case comes in the office that we both don't lay eyes on.
That's right. I mean, we like to joke around, you hire one of us, you get both of us. In almost every case, we work on our DUI cases together. We get a different set of eyes on it, somebody with different experience. Or our paralegal puts us together notebooks and files. And when you see us walk into the courtroom that day for your case, there's hours of work that we have put into your case that you haven't seen. You may come review discovery with us, but if you're reviewing it with us, we've watched it before.
And look, a lot of people only see what lawyers do in a courtroom. And a lawyer told me a long time ago that you win cases out of court, not in court. And I never knew what that meant until you really start practicing law and you realize what he means by that is the work that goes into a case typically happens at your desk in your office. That's what prepares you to be in court. And I think that's what we pride ourselves in.
That's right. It's the late nights that nobody sees. You sometimes get your best thoughts in the shower. And you do all that work before you ever step foot in front of a judge. And before you ever get that officer on the stand asking questions, we're working to try to beat your case.
Yeah.
Another question I get a lot with DUI cases is people tell me 9 times out of 10 that they were not read their rights. And a lot of people just don't understand that, or they'll tell me, or they'll ask the question, they didn't read me my rights. Does that mean my case gets thrown out?
That's right. And everybody thinks that if you don't get read your rights, your case is done. It's over with. But with DUIs, that's just simply not true. We've had cases where people were never read their rights and they proceeded to the station. They did an Intoxilyzer. Well, there's a warning you sign before you do the Intoxilyzer test that makes sure that those tests are admissible in court. So just because you haven't been read your rights in a DUI case doesn't mean you automatically win. Obviously, the rights come into play when maybe you're arrested and you say something you shouldn't have. You admit to drinking. Well, if they haven't read you your rights and there's some other conditions that apply, that may be a statement that we can suppress on the body cam.
A lot of times when people say they weren't read their rights, they're referring to the famous Miranda rights.
That's right.
Do you know the Miranda warning?
I've known from Law and Order just like everybody else.
Well, one of the things about the Miranda warnings is people don't realize is that, law enforcement doesn't have a duty to read you Miranda just because you were arrested. We routinely explain to people that they only have to read you Miranda rights if you're in custody and if you're being interrogated. And a lot of people don't understand the difference between being in custody and being interrogated in a DUI stop. And obviously, a lot of times in a DUI stop, it's an investigation before anyone's ever in detention. So.
And that's right. And there's case law on both sides of those things. And that's kind of a gray area. And that's where lawyers are really worth their money. That's where we come in. We argue the law. We apply the facts of your case to the law and try to get a favorable and a just outcome for you.
But I will say that it's very common for us to file motions and pleadings in court asking to suppress statements because they weren't read Miranda rights. And so there's a lot of times that, clients are right. They weren't read their rights, and we don't know that until we get their evidence in the case. But a lot of times there's a false belief that just because they weren't read their rights, that their case will be dismissed. So a common issue we have with a lot of DUIs is people who are charged with DUI, they have a license suspension. And they'll get an unexpected notice that their license was suspended shortly after being arrested for a DUI.
That's right. And in the state of Mississippi, if you do not blow in the breathalyzer, you come under what's called the implied consent law. And that basically allows the state to suspend your license even if you are not found guilty of that DUI, even before any of that takes place. And you'll get a little notice in the mail on the address that's at your driver's license. And I think you have, 14 days?
10 days.
10 days. You have 10 days from the time you get that notice, from the time it's mailed. Is it mailed?
I think time it's mailed.
You have 10 days from the time that notice is mailed to appeal it. Otherwise, your license is automatically suspended for a certain period by the state.
And a lot of people don't realize too that if they get convicted of their DUI, that there's a driver's license suspension that gets tacked on to your conviction, and it runs on top of consecutive to the suspension that is by the state. And something we haven't talked about is that, yes, if you refuse the breathalyzer, the Intoxilyzer, they can suspend your license. But if you take the Intoxilyzer and you blow above a .08, or if you're a minor, blow above a .02, then your license will be suspended regardless.
That's right.
And now there's a process where we can get that extended through the court.
That's right. If you get to us before the period has expired for you to respond to that letter, we can actually intervene on your behalf. And most of the time we're successful in extending your driving privileges so that you can keep your license for the time that you were fighting your DUI case.
Yeah, look, one of the things that we tell people when they call us about a DUI is we have a whole conversation about your driver's license, because a lot of people just don't understand that there's time restraints. And as important as your DUI is, your ability to drive a vehicle with a valid license is just as important. And that's one of the biggest reasons why we advise people, when we're just talking to friends and family, why you should hire a DUI lawyer as soon as possible, because we're able to get in and do things like save your driver's license, or get that piece of evidence that's going to disappear if you wait 2 months. And a lot of people just don't realize that.
Yeah, and that's the thing. We get calls from all kind of people, truck drivers that depend on their driver's license to literally survive and feed their families. We get calls from mothers that take their kids to school and sporting events. So for a lot of people, that is their primary concern is, hey, just please protect my driver's license. That's my livelihood. And so, when they tell us that, we go to work immediately to try to make that happen.
And so we do kind of, when we work our DUI cases, we do kind of split them into a driver's license part of the DUI and the DUI itself. And I mean, I would say we're pretty successful in the driver's license suspension part, keeping people's driver's license and getting them extended when we need to. All right, let me ask you a question.
Hi.
Why do you like practicing criminal defense?
I genuinely have fun, but I think the real answer is I like helping people in their toughest battles. So, people call us and they're literally, the government is trying to take away their freedom or their livelihood. And you can't fight the government alone. That's kind of why I went to law school, to help people fight the biggest companies and the government. Your rights in the Constitution are there, but they don't defend themselves.
I tell people that the government is one of the biggest things that you could battle against. And we as individuals all deal with government, taxes, whatever the case may be. And in every single criminal case, on the other side of that case is the United States of America.
That's right. They've got all the resources. They've got all the money. They've got everything is stacked against you. And it's our job to go out there and fight for you and to keep the government from doing what they like to do. Really and truly,
as criminal defense lawyers, we're not supposed to win. I mean, cards are really stacked against you when the other side's the government. A lot of times they have all this evidence against you when they walk into our office. And so 9 times out of 10, a case that walks in our office, we're immediately going into that case as underdogs. And for me, I'm competitive. You're competitive, and hate to lose. And so to me, I think one of the key aspects for me that I enjoy is being able to battle and win against the government.
Yeah, I mean, that's exactly right. And it's easy to be motivated, and it's easy to work extra hard and to stay up later and do extra resources and work when you know that your client's freedom is on the line. And it's up to us. We're the only thing standing between them and the government and them and jail.
And I'm sure you get this from friends and family, but the general idea of being a criminal defense lawyer, you get pushback. People tell you you're representing bad people. People tell you you're putting bad people back on the streets. But the way I explain it is we're protecting rights. When we protect one client's rights, we're protecting everybody's rights, including our own. And I think there's a checks and balances. And when we challenge police officers, when we challenge district attorneys' offices, we're doing that for everybody. Someone's got to do it. And I think one of the great things about what we do as a career as criminal defense lawyers, I think there's a lot of enjoyment for that and for me. But I will say too, one of the reasons I love doing what I do is I love being in the courtroom.
That's right.
I mean, I think we spend 90% of our workday in the courtroom, and being able to walk into a courtroom, which has got to be one of the most intimidating places for a normal person. And to be able to come in here and be the voice for someone, it is pretty incredible to be able to say you can do that. And obviously, it's taken a lot of work to get here for us, but I think that's one of the key enjoyments for me is being able to come into a courtroom.
I agree. And talking about a courtroom, I mean, I think one of the most important things you want in a lawyer is for somebody that when they walk in that courtroom, they're comfortable in that courtroom. If your lawyer's nervous in the courtroom or they're fidgeting, everybody can tell. The judge knows, police officer knows. And so I think when you look for a lawyer, you want somebody that spends most of their time in the courtroom and somebody that's comfortable there. And it's basically a second office for them. We spend more time in the courtroom than we do in our offices.
Look, we tell everybody we meet with, especially on serious cases, go talk to another lawyer. Get a second opinion. Don't treat us lawyers any different than you would a health condition, And we do that because we're always comfortable and we're always confident that they're probably going to come back to us. But, I also tell people that are looking for a lawyer that involves litigation, whether it be against an insurance company, whether it be against the government, go sit in the courthouse. Go sit in the courthouse and watch other lawyers. See how they interact with court staff. See how they interact with other lawyers. See how they interact with your judge. And that'll make the decision for you 9 times out of 10.
That's right. And see how they interact with their clients. See how they interact in the position that you're going to be in soon. If a lawyer doesn't have time to talk to you about your case and to give you the time that your case deserves, that's probably not the right lawyer for you.
So a lot of times we get people that call us that have a warrant out for their arrest and some information that we got to know to determine where and what kind of warrant is. We got to know what kind of charge it is. And so a lot of times if it's a felony charge, it's different than it being a misdemeanor charge.
That's right. And it depends on where in the process the felony charge is. If there's a warrant out for your arrest in let's say a city court, Pascagoula, Ocean Springs, Moss Point, you're dealing with the city court at that point, your city police department. And so a lot of people will call us and see what we can do. And the first thing we do is we'll call the city prosecutor or we'll call the investigator. And we try to immediately arrange a time for you to turn yourself in, and we try to get your bond set so that when you walk into that police station and that jail, we'll walk in with you and we'll walk out together. If there's an indictment, it's a little bit more complicated. Most of the time we got to deal with the district attorney's office.
Yeah, so a lot of times when people have an indictment, obviously the question we want to ask them is whether or not they've previously been on bond before. If they haven't been on bond before, it tells us that they've never been arrested for it before. So we're starting that case, for the most part, from the start with the client. Whereas if they've been on bond for, there's a possibility that maybe they missed court they didn't know about. Mm-hmm. So there's a whole process for us getting bench warrants lifted. And so if you got a bench warrant or you got a warrant out for your arrest, that's more work for us to have to go get that lifted. And obviously that depends on a lot of factors to get a bench warrant lifted.
That's right. And, I think if you've got a warrant out for your arrest, that's where hiring a lawyer quickly can have immediate payoffs. They're able to get you a bond that you can afford, and they're able to make sure that there's no other issues that will hold you up in jail. A lot of times we have people that show up, think it's just a misdemeanor warrant, and there's some old traffic tickets from another county that'll hold them up. Or like Cameron said, there's a bench warrant, and those are tough to get lifted. But a lot of times, we go on to show that you didn't have notice of your court date, or there was some exigent circumstance that kept you from showing up to court, and we try to get that bench warrant lifted immediately.
I think we tell people all the time that if you hire us before you bond someone out, after they've been arrested, usually for a felony crime, that we can save them our costs.
That's right.
And attorney's fees by getting the bond reduced down low enough for them to bond out, still afford the bonding company, and still afford their lawyer. And so I think a lot of people just don't understand that either.
Yeah, a lot of people think that the judge sent me this bond, this is what I got to come up with to make. And a lot of our practice is getting bonds reduced for folks that are either in jail or have warrants out for their arrest. And those are a lot of times are complicated. Sometimes we can call the prosecutor, sometimes we can show up in court, but a lot of times we have to file motions and we have to litigate those issues. And that's something that we're not scared to do.
So one thing too that I like for people to know about us is our firm, I feel, is different than other criminal defense firms. Maybe I'm biased. But I think one thing that you can agree that we do a good job of is we communicate with our clients, or whoever the point of contact is if a client's in jail, to keep them, fully aware of their case, the facts of their case, what's going to happen. We routinely say in our office that we're not going to let you show up to court without knowing what's going to happen. I think that's a key for a lot of people.
Yeah, and another big thing for us is we try to always make sure you're not going to show up to court by yourself. And you would be shocked at the amount of lawyers that will not show up to court. Lawyers are busy. We've got courts at the same time in various counties, but there are lawyers that will make you show up and ask for a continuance for the judge, and that's not how we operate. If you're going to be in court, we want to be there with you, and we try to communicate effectively. If there's an update for your case, we try to tell you ASAP.
And I think that's where us having a team approach to every case is different than hiring, a law firm with one lawyer in it, or a law firm with no support staff, because bonding companies trust us. Mm-hmm. Bonding companies love when we're the lawyers because we make sure our clients are at court. We communicate with our clients and make them fully aware of what's going on, and they don't have to do much, But I do think that's something that we feel sets us apart from other lawyers.
Yeah, and having two lawyers and a good team, we're able to almost personally return every single call that comes into our office. You'll either hear from Cameron or me or Kendall, and we take notes. Everybody in our office will be able to see what we've talked about. So it's consistency. It's a good system that everybody knows what's going on, and so you could call our office at any time, and if there's an update on your case, somebody's going to know about it, not just the lawyer that you've been working with.
Right. So one thing we pride in our firm is systems, and we've spent years trying to perfect and continue to try to perfect a system where, yes, you're hiring a lawyer because you want a certain result, but to get to that result, there's a lot of communication. There's a lot of client support staff communication. And that's where a lot of breakdown happens between the time someone hires a lawyer to get that result. There's a lot of breakdown. And a lot of times, you hire a lawyer in the front end and you don't hear a whole lot until, a week before your result. And one thing that we perfected, in my opinion, is that process to keep it steady, to keep it consistent, and to keep it open communication between us, the client, our paralegals, about what's happening in the case. And I think it's fair to say, and I think any of our clients would agree with this, that when they hire us, before they hire us, we're pretty upfront about what we think is going to happen in the case. And that's something we try to do in every single case, is not predict an outcome, but based on what's happened with our experience in handling thousands of felony cases from start to finish, we're at least able to gauge what we think may end up happening in the case and at least give a client 3 potential options.
That's right. And you know, we tell you as soon as you walk in the door, we'll never make a promise to you that we can't keep. We're never going to promise you a certain outcome in your case, because a lot of times it's not just up to us. It's up to a judge. It's up to a jury. But we do make, the only promise we make is that we will do everything we can to fight for you and to fight for your family. And you know, like Cameron said, we can give you an idea of what we think the possible outcomes are based on our experience and what we've had to deal with and the facts of your case. But every case is different, and we're prepared to adapt and handle your case in the way that it needs to be handled.
Right, and we can't change facts. We can't create facts. When a case comes in our door, usually the case from a factual standpoint is closed. And so we're dealing with a set of facts that we had no involvement in and that we can't change. You know, and so we like to make that very upfront. And look, we get bad cases. We get cases where people are in bad situations. They've done something bad. Maybe they're a habitual criminal. Maybe they're a first-time offender. You know, people joke about lawyers, about how they always say it depends. But out of all the cases that we've handled, I mean, it is rare that 2 cases are ever the exact same or even close to being the same.
That's right. I mean, even 2 similar cases, you know, both traffic stops, both similar amounts of drugs. You know, one's found in a guy's pocket, one's found in the panel of a rental car. You know, those are way different facts. And a lot of it goes into your criminal history, how you were with the officers. And there's legal defenses to a lot of these things too. You know, there's cases where if you get pulled over, officers take drugs out of your car and they never charge you with it. Well, there's a statute of limitations. Officers only have 2 years on most drug cases to bring your case and get you indicted. Now, if you're arrested or an affidavit signed, obviously that changes the calculus, but there are a lot of cases that we have success with getting dismissed based on the statute of limitations.
Right, and there's exceptions to a lot of things. You know, I think something you're great at is finding loopholes, such as statute of limitations in cases. But yeah, you know, our drug cases, you know, that's a great example of how every case is so much different depending on the set of facts. You know, and I think, you know, we're talking about DUI cases, we're talking about drug cases. Obviously, we handle a lot of violent crimes, but I still think that the fact that we've handled so many cases, such a wide variety of criminal cases that, I mean, we don't ever say this much, but really and truly, I mean, we're a full service criminal defense firm. I mean, from handling juvenile cases at the youth court, the day someone's arrested, all the way up through an appeal. We've done it all here. And I think that should be important to someone who's looking for a criminal defense lawyer.
So Cameron, you know, a lot of questions that we get are, you know, hey man, a long time ago, I had a felony charge on my record and I'm trying to get a job and it popped up on a background check. Is that something you can take care of?
That depends. So when people call us and ask us about expunging a felony crime off of their record, what they're asking us is they're wanting to remove that off their record. And so if they were convicted of a felony crime, it's going to depend on what the felony crime is. If it's a felony crime that's a violent crime, the answer is no. There's a long list of other felony crimes, such as embezzlement, that cannot be expunged off your record. But most drug crimes can be expunged. We see that a lot. And so if you're convicted of something like a drug crime and you have been 5 years off of your probation and you've paid everything off, we can petition the court for an expungement. It doesn't automatically mean that you get one. And that's completely separate from getting your gun rights back. And that's
I was going to ask you about gun rights.
So to get your gun rights back would be another topic of discussion. But most people that call us about expungements are calling us about a case they were arrested on and the case got dismissed. So if you're arrested for a misdemeanor crime or a felony crime and the case gets dismissed, you're entitled to an expungement. And we do a lot of those all over the state of Mississippi. A lot of times with our felony criminal defense work, we get people who have been charged with the crime, we look them up, they're in jail, and they have been tagged with a probation violation. My first question to you, Bay, is what does that mean?
So, a lot of times we'll have clients that get sentenced to jail or what they call post-release supervision. But after you get out of jail, or if you get sentenced to probation, you have to check in monthly with your probation officer. You have to pay your fines and fees every month. Now, after 5 years, you might not have to report to court. But what a probation violation is it's basically that you violated the terms of your court-ordered probation. Now, that can be failing to report. That can be committing a new crime. That can be not paying your fines and fees. But where they really get you is, if you just commit a misdemeanor or you violate a condition, they'll send you what's called the technical violation center. A lot of times, that can vary from 90 days to 180 days. But if you fail to report for a period of longer than 6 months, the court can sentence you to jail for the remainder of your time. And I know, Cameron, you've had a lot of experience litigating probation violations.
And we tell people from the beginning, those are very tough cases. Those are very tough cases because if you go in front of a judge on a probation violation case, they're going to say, you've been given a chance, you're back before me because you've gotten in trouble again. And so we get very, very little leeway with judges when it comes to probation violations. A lot of times the work that we can do on them cases, a lot of times include fighting the crime that they've been charged with that violates their probation. So, if you get arrested for a DUI, you get arrested for domestic violence, that'll violate your probation. And we tell people who call us on that, well, yeah, the probation violation is there, but we got to fight the underlying crime. And so that's where a lot of our work goes in on probation violations. And obviously the law has changed in probation violations over the years that require certain notices and time restraints, but it hasn't changed the fact that they are very difficult cases, and we handle a lot of them.
That's right, and probation is different than parole. If you're in prison and you make parole, you'll be out on what's similar to probation. You'll have a probation officer, still have to report, but if you violate, you will go in front of the parole board. And the parole board has a lot of discretion, a lot of latitude, and they can sentence you to the remainder of your time for pretty much anything. So those are serious cases. They're tough cases. But another form of probation is non-adjudicated probation. And I know you've got some experience dealing with non-adjudication.
So if you're a first-time offender, a lot of times if you plead guilty to a crime, you are eligible for non-adjudicated probation. And what that means is the court accepts your plea of guilty, but withholds adjudication of guilt, puts you on probation. For a drug crime, it's usually 3 years. For other crimes, it's usually 5 years. And complete your terms of probation and your charge gets dismissed. You can expunge it off your record. You violate your terms and you're facing a probation violation.